Hey, everybody. I am super excited to have you all in our annual legal update. It's Be the Change HR, and we have Andrea Paris Law with us here. So we'll be going over both California and federal employment law. Next slide for me, please. So this is Andrea Paris. She's our employment attorney. And then you all know Chrissy and I. So Chrissy is our COO, and I am the CEO here at Be the Change HR. Next slide. Just a little bit of housekeeping. So feel free to screenshot anything you see here. The only ask we have is that you tag us on socials. So, at Be the Change HR, and for Andrea, it is at Women at Work. And then again, submit any questions that you have as we go along, either into the chat. I'll be taking a look at that, or you can put it into, there's a little button at the bottom of your screen, Q&A. Submit it in there. And with this, I will turn it over to you, Andrea.
Thank you, Leilani. Thank you, everyone, for giving up part of your time today to be with us. And thank you, Leilani, for inviting me and being here with me. Lawyers, we're not known for being fun, but Leilani always brings the fun. So I'm really excited to be here. Disclaimer. So I am not your lawyer. Unless you happen to be here and I am your lawyer, then I am your lawyer. But the information provided today is for informational and for educational purposes only and is not meant to be legal advice. So now we got that out of the way. Let's jump into our 2025 legal updates in employment law. So I know that we're doing California and federal. I don't really see any major updates on the federal front other than on the minimum wage. So today will almost entirely be related to California legal updates. So California minimum wage, the state minimum wage increased from $16 to $16.50 an hour, which means that the minimum salary test for the exemption from overtime and meal break and rest break rules, the salary for that salary test is now $68,640 per year, or $5,720 a month. Now, although the state minimum wage is at $16.50, there are special categories. So make sure that you check your local minimum wage. If you have workers in various cities, make sure to check the minimum wage for the cities in which your workers work. Also, fast food workers, the minimum wage is $20 an hour. And then there was a new law that went into effect this year in 2024 related to the healthcare industry, or also businesses that support the healthcare industry. For example, I had somebody come in and I had to help them do an analysis. And what they do is actually provide administrative support for clinics and physicians. So they were subject to the higher minimum wage as well. It's very detailed and very fact specific. So if you are in the healthcare industry, I recommend that you reach out to Leilani and her team and figure out whether you are subject to this higher minimum wage law. On the federal front, the federal minimum wage is $7.25 an hour, and it is $17.75, an increase from $17.20 for federal contractors whose employees are working on or in connection with covered federal government contracts. So if you are a federal contractor, your minimum wage threshold has increased. And the exemption from the minimum wage requirement for the exempt workers on the federal side, the salary is now at least $35,568 per year, or $684 per week. Now, if you are compliant with California minimum wage, you will be okay on the federal front unless you are a federal contractor. I just want to note that on the local minimum wage, the cities are all over the place. So definitely check your city's minimum wage requirements. The highest one that I saw was West Hollywood, and the minimum wage for West Hollywood is $19.65 an hour. Okay, the next law that we're going to talk about, and I will go through these pretty quickly. You can get a copy of the slides, and a lot of the details are there. On the sick leave expansion, also, if you need more details or you want to read the law yourself, the reference to the bill that was passed will give you all the details. So if you look up AB 2499, you will get all the details on the sick leave expansion. Okay. So sick leave expansion. Updates to Labor Code Section 12945.8. And it provides employee protections. So employees in California can now use sick leave, not just for themselves, but also to assist any family member. And family member is broadly defined to include these categories: a child, a parent, grandparent, a grandchild, a sibling, a spouse, a domestic partner, or a designated person who is a victim of certain types of violent incidents or threats of violence. So this expands to beyond just the employee being a victim of domestic violence, assault, or stalking to include family members. And that label designated person is one that was added to the sick leave law this year in 2024. And a designated person is somebody that the employee gets to designate who could be a family member, who is related by blood, or somebody who is not related by blood, but to whom the employee has a familial relationship with, or one that feels like a familial relationship. And they can designate one person every year. The other change in the sick leave law is that it expands the reasons an employee can use paid sick leave for save time purposes. And these reasons that an employee can use sick leave is really, really broad. So they can use the time to obtain relief from court, and that is to go to court to request a temporary restraining order, for example, or to testify in a criminal proceeding against a perpetrator. To get medical attention, and that is for their own medical attention, or to assist a family member who is a victim of violence who needs medical attention. To help a family member find shelter, for example, to help a family member get assistance or get counseling, to help a family member relocate, or to participate in safety planning, um, to prepare for legal proceedings. So, for example, if a family member needs support because they need to have a meeting with an attorney or a meeting with the district attorney's office, or even to find childcare for a protected child. So the reasons are expansive. And the other change in the sick leave law is that employers now have a duty to reasonably accommodate employees who request accommodations related to either their own or a family member's status as a victim of an act of violence or a threatened act of violence. And um, so, for example, this may include implementation of safety measures. And I will go through tips towards the end. So we do have some tips on that front. We also have, here's a list of employers' rights. So employees have the right to sick leave and to accommodations. Now, on the employer side, you may request certification or request proof of their status or need of accommodations, and you can request certification every 6 months. Now, it should be reminded that what qualifies as certification is defined very broadly. It could be a doctor's note. It could be a letter from an attorney. It could be a letter from a counselor. It can even be the employee's own signed declaration. They can sign and say, I sign stating that, I have a family member who is a victim of domestic violence, and I do this under the penalty of perjury. That would be sufficient. You may also require that employees use their time off that is available concurrently with FMLA or CFRA leave. And you can also place limits on leave for a total time of up to 12 weeks. And if it's for a family member and not the employee themselves who is a victim of domestic violence or other acts of violence, and that family member does not pass away or is deceased from that act of violence, you could limit the time off to 10 days, or you can also limit the time off to 5 days to help with relocation. So these are the things that you would want to update and provide in your employee handbook, really for your own reference, so that you kind of know what the rules are, so that employees also know what the rules are. Now, the great thing is that the law actually requires the Civil Rights Department to create a notice form. So I would recommend to all employers go to the Civil Rights Department website, get a notice form from the department, and provide a copy to all employees. Make it a part of your hiring packet. Give to all employees when you update your handbook. Also, update your handbook and alter the language in your sick leave policies to be compliant with the law. Train management and human resources professionals so that they are aware of the new changes, and let them know that leave is no longer limited to just the employee being the victim of domestic violence, sexual assault, or stalking. Now, I like to think of triggers. So for me here, the triggering part is when an employee provides notice to you that the employee is a victim of violence, or that they have a family member who is a victim of domestic violence or other acts of violence. Now, once you get this notice, once you have this knowledge, it triggers the obligation to provide time off for them to attend to legal proceedings or whatever other things that they need. You could ask for certification, and it also triggers the requirement that you provide reasonable accommodations to the employee to ensure their safety while they are at work. And these accommodations could include transfers. It could include a modified work schedule, a changed phone number, the permission to carry a phone at work. So you will have to work with employees unless it is an undue burden, to find these ways to protect the employee while they are at work. Okay, so that is on the paid sick leave. Now we are moving on to AB 2123, and that is the paid family leave. So paid family leave provides up to 8 weeks of paid benefits from the EDD. So this is separate from the employer's obligation, but the EDD provides up to 8 weeks of benefits to employees of subsidized wages for the care of the employee's seriously ill family member, to bond with a child, or for qualifying events because a family member is being deployed with the military. What this law does is that it removes the provision that allows employers to require employees to use up to 2 weeks of accrued vacation time before they can start receiving paid family leave benefits. I don't usually have those in my employee handbook, but I would check to see if that provision is in your employee handbook. If it is, then you would want to delete that and know that that requirement is no longer one that is available to employers. Next one, SB 1090 allows employees to file claims for state disability insurance and also for PFL, which we just discussed, up to 30 days in advance of the first compensable day for benefits. This allows the employees to not have that gap in pay while they are off for any of those qualified reasons. So that doesn't really affect the employer, but is a benefit to the employee. So you may want to give employees that notice because it is to the employee's benefit to not have that gap in pay. And So I would definitely update the employee handbook, that section of the employee handbook. Now we move on to discrimination. Here, so this is SB 1137. It really just clarifies case law. It doesn't really add anything or change anything in the law. I think it just makes clear what case law has been determining, in the past few years. And it clarifies that the protected characteristics under the Fair Employment and Housing Act, or FEHA, includes any combination of the listed protected characteristics. And this list is a long one. We've listed them all here for you, but it's, your race, religion, color, disability, medical condition, marital status, sexual orientation, reproductive health decision making. That was a new one that was added this year. But any combination. So somebody could be discriminated for a combination of these characteristics and not just for one. But also, and I don't know if a lot of employers know this, but on the litigation front, we do make this argument a lot that discrimination includes a perception that the person has one or more of these characteristics. So if there is a perception that an employee is of a different race, even if they're not, or a perception that they have a disability, even if they don't, that is sufficient to serve as grounds for a discrimination claim. Captive audience meetings. So AB 399 creates this new act called the California Worker Freedom from Employer Intimidation Act. And this is an interesting one. So it prohibits the discharge, discrimination, or retaliation against or threat to carry out such actions if an employee refuses to attend any employer-sponsored meeting related to religious matters, political matters, or any decision-making related to labor organization or union discussions. And you might think, who does that? I will assure you that I have seen it, or I have seen claims related to this. So I have defended a lawsuit where, and this is public record, so I can share, but I defended a lawsuit where an employee claimed discrimination because he did not want to participate in an event that was one where the employer wanted everybody to come up and kind of share what they were grateful for. So this is where you can go, okay, what constitutes a a meeting related to religion, a religious matter or a political matter? So the employer apparently asks people to come up, share what they're grateful for. They can offer prayers if they want. They can, not pray. They can meditate, do whatever they want. And then the employer proceeded to have somebody come and check the feng shui of the building, sage the building, and the employee claimed that he felt that that was a religious activity and that he was discriminated against because he did not want to participate in that activity. So it will be interesting to see. And this was before this law came out. So now that we have this law, I think it would be really interesting to see how far people go with what they claim to be uncomfortable with. So if you are going to have anything that could remotely be defined as a possibly religious activity, do it off company time. Definitely make it optional. Do not make it mandatory. And I think where people run into trouble is sometimes employees will claim that, yes, although they say it's not mandatory, I feel that if I do not go, I will be retaliated against. So maybe stay away from it totally. But just be aware that this is something that will likely come up in the future. The next one, so now we are going to job postings. SB 1100 now makes it illegal for employers to post in job advertisements, applications, or other employment materials requiring that an applicant must possess a valid driver's license in order to get the job, unless the employer can prove, one, that the employer reasonably suspects driving to be one of the job functions of the position. Of course, if you're going to be an Amazon delivery driver, you will need a valid driver's license. But if it's not part of the job to drive, and if the employer does not reasonably believe that an alternative form of transportation, such as biking or public transportation, that does not require driver's license, would not be comparable in travel time or the cost to the employer, you cannot make having a valid driver's license a requirement of the job. Next is AB 2299, and this is more of a law with a about a notice requirement of the whistleblower protections. So here, again, you can go, this is the great part. I love these when you can go to the Labor Commissioner's website. So this one, go to the Labor Commissioner's website. It's a different website than the one we spoke about earlier. Earlier, it was the Civil Rights Department. Now, this is the Labor Commissioner's Department. You can go to their website and get a list of rights and responsibilities and make sure that they are posted. It gives you the list of, the whistleblower protected activities and classes, and it has to be printed in 14 or larger font and make sure that that is posted and distributed to your employees. Another notice requirement, AB 1870, now requires that workers' compensation posters provide language of an employee's right to consult with an attorney regarding a workers' compensation claim, and also that the fees for the attorney will be paid from an injured employee's recovery. This is to prevent or allow employees not to feel like they will have to pay out of pocket for workers' comp claims, which may prevent employees from filing claims or seek the consultation of an attorney. So this is now required as part of your workers' comp notice. The next thing we have is the Freelance Worker Protection Act. This one I provided a little more detail on because we use a lot of freelancers, and this is a whole new law, requirements related to freelancers. And a freelance worker under the statute is defined as follows: a single person, whether that person is incorporated or not incorporated, to which the company pays at least $250 in the aggregate over a 120-day period. A freelance worker the definition of a freelance worker who is subject to this law does not apply to someone that you hired to perform personal services for you or for a family member. So, assuming you are going to work with somebody who qualifies as a freelance worker, the number one requirement is that you have a written contract. And the written contract must include, and it's a very detailed list, name and mailing address of each party, an itemized list of services to be provided, a date when payment is due, or a way to determine when payment is due, such as 10 days after the delivery of a website. The date that services under the contract are due in order to process timely payment. I mean, these are things that you should have with an independent contractor anyway. You should have a contract, and these terms should be laid out. And now it is actually a legal requirement. Next is that once you have a signed contract, the company must provide a copy of the signed contract to the freelance worker and also keep a copy for yourself. Now, the law only requires that you keep it for at least 4 years. My recommendation, and we have tips at the end, but my recommendation is to keep a copy of the contract for at least 4 years from the last date that you worked with the freelancer. And that's because the statute of limitations for breach of written contracts is 4 years. So you want to make sure that you have a copy of that contract in case there's ever a claim of breach of the written agreement. Next, the law requires that payments meet the following minimum requirements. So one, has to either be made on or before the date that compensation is due pursuant to the contract, or no later than 30 days after the completion of the work, if there's no time frame provided in the contract. Now, if you don't provide a time frame, you've actually violated the first part of the statute, which requires that you list out a time frame. So that could go to the calculation of your penalties and what your exposure would be for violating the law. Fourth, the law prohibits setting the following conditions to the freelancer receiving payment after they have started work. So one, you can't force the freelancer to accept pay less than the amount specified. And two, you cannot require that they provide more goods or services than what's outlined in the contract in order to receive payment. So make sure that your agreement is written well, that it provides for modifications in writing so that if modifications need to be made, you can make those amendments to the written agreement in writing. Make sure both parties sign it so that then that becomes the new agreement. Fifth, the Freelance Worker Protection Act prohibits discrimination or any adverse action against a freelance worker that penalizes the worker or is reasonably likely to deter the worker from taking any of the following steps. And one is that would prohibit them from opposing any practice prohibited by this new law, from participating in a proceeding related to enforcement, to seeking enforcement rights, or otherwise asserting or attempting to assert rights provided by the law. So essentially, it's saying don't discriminate, do not retaliate if a freelancer is trying to enforce the law. So if a freelancer ever sends you an email and says, hey, we need to have a written agreement, and you go, no, we're not going to have a written agreement, or if you require a written agreement, we're not going to work with you, those things will provide the freelancer with a potential claim against your company. And we always want to know so what? So what if there is a law? So the cost for violation of this Freelance Worker Protection Act is that one, the freelance worker can recover attorney's fees and costs. Actually, it goes to the prevailing party. So if you prevail, you could recover your attorney's fees and costs, which puts companies in a much better position than they otherwise are in most employment cases. But also the risk that if the freelancer is correct, you would have to pay their attorney's fees. Additionally, there is a $1,000 penalty to the payment to the freelancer if they ask for a contract but was refused. This is the separate cause of action. Another penalty is payment of twice the amount that remains unpaid at the time payment was due if the hiring party failed to pay according to the time frame required by law. So there's a penalty there. And there's also the possibility of damages equal to the value of the contract or the work performed, whichever is greater, for any violations of this law. So the tip is create an update your template freelance agreement so that you can use it with various freelancers, maybe a form master services agreement and amendments that you provide with a list of the services that are to be provided, time frame for payment. Just make sure that you meet the requirements outlined by the law and keep the agreement for at least 4 years from the last date that you worked with the contractor. And I think that is the quickest I've ever done a presentation, but I do have a bonus. I have a quick bonus. Okay, since we have a few minutes. I also just wanted to remind everyone, this is not a 2025 update, but it was a big update for 2024, and that is the PAGA reform that was signed into law mid-year. So the main takeaway really, I mean, it's a lot of detail on the PAGA side. A lot of it deals with litigation. As an attorney, it's, things that I need to know. But on the employer side, the main takeaway is, one, you have the ability to reduce your PAGA penalties by 15 or 30% if, one, you take efforts to proactively comply with the labor code before receiving a PAGA notice. So this is a perfect time, if you haven't done it already, do your audits, review your pay practices, review your wage and hour, practices, review your classification of employees, because just being able to show the efforts that you made and if you made any changes or you conducted an internal audit, that can help significantly in reducing your potential exposure to PAGA penalties if you do get a notice. And the other thing is, if you do receive a PAGA notice, in the past, it's very rare that employers would go through the process of trying to cure any of the claim categories. There were only categories that you could cure, and the cost was extensive. But now the cost benefit has increased significantly. Benefit has increased significantly compared to the cost, because you could have your penalties reduced if you do, quickly fix the policies and practices contained up in the PAGA notice. And then there are a broad category of violations for which you could cure and, potentially get those claims out of litigation entirely if you are able to cure and make your employees whole. So that, just a reminder, there really is a big benefit to conducting an internal audit at this time because of the PAGA reform.
Andrea, can you explain what PAGA is?
Oh, sure. So PAGA is it's called the Private Attorney General Act, and it allows an employee to step into the place of the labor commissioner, essentially, to prosecute labor code violations on behalf of themselves and other employees. Now, it used to be on behalf of themselves and other employees, regardless of whether the other employees suffered the same violations that the PAGA representative suffers. But with the reform, now the representative employee, for example, if the employee claims that they suffered meal break and rest break violations, and that's it, they can't also prosecute for overtime violations, failure to reimburse, and everything else that other employees may have suffered. So it reduces the scope significantly, but it's like class action light, except it's mainly just for penalties, and it just has a 1-year statute of limitations.
We will follow this up with a list of all the legal changes around the United States, a copy of this deck, Andrea's contact information. So you'll get all of that if you have any follow-up questions or you want to work with her.